this continued pattern of disregard, okay, in basically so many different areas is very, very concerning because it's impacting the trial.
Good morning, Your Honor. Joel Odou, Mark Love, Eric Freeman, and Matt Kaufman on behalf of the real water defendants.
Good morning, Your Honor. Valerie, Rojas, Dan Waite, Jan Tomasik, and Abe Smith on behalf of defendant ETT.
Okay, do appreciate it. So, counsel, the court had made its ruling yesterday, but I know at the end of the day there was an issue that Mr. Kemp wanted, but because it was past the closing time and things already been we're operating, people are packing up. So, Mr. Kemp, you're standing up, so I will see, is there still an outstanding issue that you need the court to address?
Yes, Your
I'll
Honor.
circle around to everybody else. Go ahead, please.
And Your Honor, we filed a bench brief this morning. I'm not asking you to reconsider your
Do you have
decision.
a copy of the
I've given the counsel copies.
out of the court? Sure.
I can
Right,
approach, Your Honor?
yeah, the marshal's out with the jury, if you don't mind, please, thank you so much. Okay, you can appreciate it since you just handed it to me,
I can appreciate it.
that I have not yet had a chance to read, particularly since I've been in other hearings all morning, you just handed it to me. So, do you want to give the court an opportunity to read said bench brief and everybody else before, or do you
Would you
want
like
to
to
jump in?
take 5 minutes, Your Honor, to read it?
Well, if you're going to address it, yes, I would like to take a moment. Would any of the council like to take a moment to read it, or did you already have it for a while?
Your Honor, we're doing that right now.
You're reading it right now?
Yeah, it was just handed.
So would you like to pause for a few moments so everyone can read it?
I'm certainly fine with that on behalf of Rojas.
Okay, Council ETT?
If we can have more than 5 minutes, Your Honor, maybe 10 minutes to take a look at this.
Okay.
Mr. Waite and I, we're here at the courthouse when it came in, so I'm looking at it on my phone and then I just got the courtesy copy, so I'm like, that an opportunity to get
Okay.
Your Honor, we have one other matter.
Okay, hold on a second.
Oh, I'm sorry.
No worries, I just, there are some people talking as they were coming in, and we can pause for a second to give you a clear record. Go ahead, please.
Going through security this morning, there was kind of a log jam, and I motioned for some people to go past me as I was getting my stuff, and afterwards I realized one of them was a juror. There wasn't any communication or anything, I just wanted to let everyone know.
Okay, appreciate that. Is anybody requesting in light of that disclosure that the court do anything?
No, Your Honor.
ETT?
No, Your Honor.
Thank you for your disclosure. Okay, we'll go off the record for a few moments. Remember, the jury's going to be on right at. You all have to come in early, you're coming in early. Okay, appreciate it. I'm still talking. You remember me?
Yeah.
Really, counsel? What was talking back to the court and talking to somebody else?
So you're going off the record now, so you could do your
The court was explaining with regards to the jury and the timing in order to address the request. So I guess I must need to speak louder, which is kind of difficult right now, in light of, as you can appreciate, the current circumstances. Okay. Now we'll go off the record. Please wait till the red lights go off, counsels. Hunwardsen versus Infinity Lifestyles, case 831543. Same counsels, same parties. Does anyone want to make an appearance today that may not have been here on other days? If so, we'll be glad to add you to it. Anybody want to make an appearance? Let me know. Nope. Okay. So the court was handed after after 9 o'clock. There we go. A bench brief regarding birth defect disclosures. As everyone knows, based on an objection that was raised and based on information presented to the court after giving everyone a full opportunity to be heard and even delaying them so that everyone would have a chance to be prepared, the court made its ruling based on what was presented to the court. So, counsel for plaintiff, let me hear what you are saying, requesting, etc., because this is a bench brief, same thing we've said to
Yes, sure.
everybody else. This one does not ask for affirmative relief, it gives information, but find out what your context is, because I appreciate there's certain witness still on the stand. Go ahead.
Context is important, Your Honor.
Mr. Parker, can you please move my mic?
Your Honor, I would object to Mr. Kemp arguing this was the issue addressed by Mr. Parker, and we've been held to the one horse, one rider rule this whole trial.
Your Honor, actually, they were precluded from participating in the compensatory phase, so I don't think we should have seen anything yesterday, but
Well, if you're yesterday without objection, I have Mr. Love and Mr. Odou, I appreciate it was just some exhibits, both quite raising things, and you and Mr. Waite were doing it, so, but substantively, the issue, does the issue relate just to Dr. Hutson? Or
Yes,
is
Your
the
Honor.
bench, is it just to Dr. Hutson? That
yes,
Mr.
if you're
Parker
Mr.
is going to
Parker,
be the one
the
that's,
argument he's prepared to do second.
that Mr. Parker, one horse, one rider, if it was a broader issue that impacted the trial overall, then what would you do to address it differently? But this is Dr. Hutson, that means it's Mr. Parker. If I have the objection, go ahead, please.
And Your Honor, just to start off where Mr. Kemp left off, I made the point at the bench that I thought it was out of place and improper for ETT to make any objections during compensatory time. And the court also,
And remember, things of bench are not part of the official transcript, it's what's reminded you multiple times. Anybody who wants it outside the presence, you know how many times we've excused this jury so that people can argue things outside the presence.
and it was really, Your Honor, once we read outside the presence of the jury as well. And Your Honor, this bench brief originated with our concerns regarding professional rule of conduct 3.3, catered towards tribunal. And Real Water objected as a joinder to ETT's objection. But ETT, again, in our opinion, does not have standing to raise an issue on compensatory, nor have they even made the point that this does not go to compensatory. So, Your Honor, first, I want to start there. The bench brief, Your Honor, turning to the bench brief, is focused on the difference between what's an opinion versus what's a fact. There is no dispute in this case that the anti-rejection medication that Mr. Hunwardsen is on and will be on for the rest of his life will result in birth defects if he had children. There is no dispute on that point at all. Your Honor, to me, it's
Okay,
akin.
but counsel, the reason I'm going to stop you for a second, right?
Correct, Your Honor.
Is because, remember the purpose of the 7.27 brief, right, is to inform the court of a point or issue that's going to come up before the court. It's not a motion in which to argue affirmative relief. So I'm just making sure people are just kind of elaborating on a point of information, but if you're going to relief, then I have to address this right in a different context. So can we clarify where you're at?
Of course,
We
Your
had a
Honor.
similar issue earlier on a 7.27 brief, and we're fair is fair to everybody, so.
Absolutely, Your Honor. I would not ask you to treat the plaintiffs any better than you would treat any other party to this litigation. We're saying this because we know what questions will be coming in the future for Dr. Hutson. Your Honor, he should be able to, going forward, addressing a fact as opposed to opinion. So perhaps when I asked the question initially, it was seeking an opinion. I want to clarify that because going forward, we will ask him if the medications that Mr. Hunwardsen will be taking, in fact, result in birth defects if he were to have children. And is that based upon the medications themselves as opposed to his opinion of the medications? This is no different, Your Honor, and tantamount to someone telling you, which he's already done, that Tylenol can result in DILI. That's a side effect of Tylenol. It's a fact. It's in the literature. It's in the medication. So it's no different than him saying it's a fact that these anti-rejection drugs will result in birth defects. The warnings are on the labels. And so Dr. Alsina has talked about it and confirmed that fact. The medical care and attention that Mr. Hunwardsen received in the hospital and through his treating physicians has confirmed that fact. There is no dispute on this issue. And so it is not a new opinion because it's not an opinion. It's simply a factual statement to which no party in this room disagrees. So, Your Honor, that's why we believe going forward, and like I said, I'll fall on the sword in terms of whether or not I asked him initially as an opinion, as part of his opinions. And I will establish it as a fact. And I believe we're not precluded from doing so, Your Honor, because no one in this courtroom, including their experts, disagrees with the implications of taking anti-rejection drugs by Mr. Hunwardsen.
So are you saying this from a prospective manner that
Of
you're
course, Your
informing me? I mean, folks, here's what we're trying to do, and you all, know you're very, very experienced and working fairly impartially. It's just, if you're asking for some relief now, then
We're not, Your Honor. Like I said, I fell on the sword in terms of how I phrased the question. And I understood the court's decision yesterday because the court was analyzing it from an opinion standpoint, and that's why the court looked at his report.
if the objection was outside the scope, the court has to look at things as you don't present them to the court.
Right, and if it was a new opinion or an opinion versus a fact, that was not discussed yesterday. That was never raised yesterday. But in the interest of not only time, but making sure that the court was fully informed, because the court hasn't seen Dr. Alcina's deposition, the court hasn't seen plaintiff's deposition. So we're giving this information to the court, so the court has now a basis moving forward on this fact that no one can dispute, Your Honor.
Okay. Counsel for real water?
Your Honor, Mark Love for Real Water. First of all, let me just comment that though our objection appeared as a joinder, it was just because EGT's counsel was quicker on the gun than we were. We would have made that objection first had we gotten it in more quickly. Secondly, I mean, I think this all comes down to the fact that this was not in Dr. Hutson's report. He did a rebuttal report. It wasn't in the rebuttal report, so it is an opinion beyond the scope. Mr. Parker trying to portray it as a fact as if it was, you know, whether the earth has gravity or not is not really well taken. It's an issue that's going to be in dispute. And Dr. Alcina will be here testifying next week.
Okay. I'm going to have a question, but I'm going to hear ET&T speak first before I ask my question. See if it gets answered. Go ahead, please.
Thank you, Your Honor. Valerie Rojas for ET&T. First of all, to just briefly address the standing issue, just because the court sanctioned ET&T by precluding us from questioning and cross-examining certain witnesses and presenting certain witnesses, that does not mean that plaintiffs can disregard all of the rules. And if we don't object in order to protect ET&T's rights with respect to the rules, then there is nobody who can object for us. And that was the reason that I did object yesterday as being beyond the scope. I recognize that Dr. Hutson may have addressed certain side effects in his report, but he certainly did not address this $50 million claim concerning birth defects or the inability or impact on Mr. Hunwardsen's ability to have children. It's not in his original report or supplemental report. And as we were sitting here, I quickly looked through his deposition and didn't mention it in either deposition in those places. And I understand what Dr. Alcina testified to. It is in fact disputed whether a liver transplant patient can be placed on certain medications or can be treated in a certain way in order to avoid those potential impacts on the ability to have children. I understand Dr. Alcina is going to testify and we can deal with that issue when it comes up, but the fact is Dr. Hutson did not address this issue specifically in either his original report or a supplemental report, and under 16.1 A2B, he has to put it in his report, and it's just simply not there, Your Honor, and that's the reason we objected. Thank you.
Okay. This takes on a lot of different things. Well, is anyone contending that the court can take into consideration the deposition testimony of Dr. Hutson. Is anyone stating it was properly lodged EDCR 2.69C?
ETT is not, no.
Neither is real water.
Properly lodged, you mean today, or?
EDCR 2.69C says what it says. That's why the court cited the specific provision. Was it proper, is anyone contending it was properly lodged with the court, timely and properly lodged under EDCR 2.69? Yes or no?
And Your Honor, you're asking about Dr. Hudson's deposition?
Yes or no? ETT, yes or no?
No, we didn't lodge it. That's all I mean.
Real water?
Your Honor, Joel Odou for real water.
No, same,
All right.
one horse, one rider, right? It was exactly 2 by 1. Fair is fair to everybody, folks.
Your Honor, I mean, it's our belief that it was lodged, but I mean, it was, okay.
You're
It's
saying,
our understanding
as an
that
officer of the court counsel, you all lodged properly under EDCR 2.69, Dr. Hudson's deposition on what date? Please provide anything that shows that you did, please.
Your Honor, we have a little time to chase that down.
It's the same question the court asked last week, remember? No, we haven't. Okay. Councilor Plano, you lodged it. I recall you from last week stating that you have no reason to lodge it. Is that what you said, words to that effect?
That's the exact answer, Your Honor. We did not, we didn't take the deposition, so we didn't have it to lodge.
Okay. The court would need to know the answer to that, would I not? If it's being relied on? The reason why the court's asking the question, some of you, there's an email that was sent that was an ex parte communication to my JEA that was not provided to the court. By a
Your Honor,
particular firm. Okay? So I'm explaining why the court's asking the question. So you can appreciate said ex parte communication, right, can't be considered by the court. But so that's why the court's asking the question. But reportedly said communication happened last Friday, which is why this court's asking the question. Last Friday would not have been timely under EDCR 2.69.
So, Your Honor,
That's why the court's asking the question. Does everyone understand that?
as I understand the question is when was the Dr. Hudson deposition transcript lodged? And
Sure.
we show that it was lodged 1:12 p.m. on January 4th.
So after calendar call?
That would have been after calendar call, I believe. Yes. All right, Your Honor, and as Your Honor will recall, we paid sanctions to a charity for being late in getting our transcripts lodged at the trial hall.
Once again, the reason why the court is asking the question is as of last Friday, one of the firms here should know what I'm talking about because they sent the communication. Now the court didn't review the communication because it was an ex parte communication, did not CC the other parties. Is everyone saying that nobody sent an email to my JEA late in the afternoon on Friday?
Your Honor, my staff may have, but
Mr.
we,
Tomasik, I can't hear you.
oh,
Oh, sorry.
Your Honor, my staff may have. We were out of an abundance of caution delivering some more sealed transcripts.
How could you under EDCR 2.69?
Well, we
How
were,
could you communicate with my JEA without CCing everybody else?
I understand, Your Honor. All we wanted to do
Please
was.
stop. You know how many times this board has asked you all to please follow the rules? Please do not engage in ex parte communication. Are you saying that that communication was CC'd to everybody else?
No.
Is it proper to send communications to court staff without CCing everybody else?
No.
Particularly when you're in the middle of trial? Particularly when you're apparently trying to add things to a record and the court's already told you you can't? Does no one notice those boxes sitting out there? Taking a look to see whose they may be, the tripping hazard that somebody dumped and left there last week? Nobody has? So. Raises different challenges and questions. I mean, for your water, you're saying you did kindly use Dr. Hutson's on the calendar call, and the ex parte communication that purportedly addresses Dr. Hutson should just be disregarded, or is that on you all's behalf too? Do you even know what I'm talking about?
Your Honor, I have to apologize. I did not know that my staff sent an ex parte communication concerning.
Don't you have to? Because hasn't the court asked
You're
you all
absolutely
over
right.
and over and over again not to keep doing this?
You're absolutely right, and I will talk to them.
And
I was not aware of it. I obviously wasn't on it, but I will address it, and I do apologize, Your Honor. We're not asking that it be considered.
so the only thing for counsel for real water is what you submitted the entirety of Dr. Hudson's deposition. You have to realize the court doesn't know because it finds out that there's supposedly an ex parte communication on a Friday that supposedly involves depositions, including witnesses for next week, right? The court can't consider it because it's ex parte, and so is what you all lodged on the 4th, the actual original deposition that should be considered? Somebody's got to tell me, please.
Yes, Your Honor, on behalf of Real Water, we were unaware of that communication by AT&T, but we did lodge Dr. Hudson's deposition on January 4th. I'm sorry. Okay. No.
So it's yours, the official. You understand that supposedly 2 people are saying that they have the official original deposition. That presents a question for the court. So was yours the official deposition to be lodged?
Your Honor, is it all right if I answer this question?
Does anyone mind if Mr. Odou seems to have the knowledge? Can he answer the question so I don't have to keep on having people whispering ears? It's not substantive. Does anyone mind? Counsel for plaintiff, do you mind?
I don't mind, Your Honor.
Okay. Counsel for ETT, do you mind? Since Ms. Rojas just stood up and Mr. Tomasik just also stood up, so we already had 2 people on theirs, contrary to what the court has said. Yeah, Mr. Tomasik first, stand up and answer certain things, and you, Ms. Rojas, stood up. So in fairness, Real Water gets to do the same thing, and then Plaintiffs' Counsel, please, gets to do the same thing. So, sorry, Mr. Odou, would you
Thank you, Your Honor.
maybe add some enlightenment to this quandary that
Yes, Your Honor. As the court will recall, a calendar call, the issue arose whether we had lodged the plaintiff's depositions. We had admitted the calendar call that we had not. We had made a contribution to a charity, and we had those plaintiff's depositions lodged the next day.
everyone was given the same opportunity
They
for the
were.
hoops factor?
They
Right,
were, Your
then
Honor.
set in stone. Didn't do it by then, everybody knew they were excluded. What this court recalls saying, you recall the court saying that?
Yes, Your
All
Honor.
parties agreed because you wanted the extra day.
Yes, Your Honor. And so we lodged the plaintiff's depositions in compliance with what was said at the calendar call. I am unaware of what was lodged after that. Real Water is unaware of anything lodged after that. There was a request late in the day to lodge a doctor deposition by somebody else. I don't know if that was lodged that day, and I'm now very confused if that was Dr. Hutson or somebody else. I just don't know.
But your co-counsel said it was at 1:12. You understand,
And that was the other one that was lodged. If Mr. Freeman believes that one was lodged at 1 o'clock, it just was not within our knowledge, Your Honor. They had contacted, Mr. Freeman had contacted
Co-counsel?
litigation services. My co-counsel contacted litigation services and said, you missed one, please get this one in. I didn't know one way or another if I made it on time. I have a picture of the ones that our firm lodged that were delivered in a box. There was no ex-party communication. I'm completely unaware of whatever happened last Friday, because this was not last Friday.
I don't understand. I mean,
It was Dr. Najim and Hutson.
Oh, I guess it was Dr. Najim and Hutson, what my co-counsel's telling me, on the day after the calendar call.
Correct.
That's the only information we have.
so real water added to ones that you specifically said in court? Is that what
No,
happened?
Your Honor, the court had given all parties a counter call
Right,
to
an extra day.
last
I-
chance.
I gave everyone, it's like,
You
let's just
did.
get it done.
The court did, and we got it done within the time provided by the court. It was the plaintiffs and Dr. Najim and Dr. Hutson. So we complied with the court's order. Real Water is completely unaware of whatever may have happened last Friday. That we have no knowledge of.
Anyone? I mean, somebody had to authorize the communication, and it sure wasn't the court.
Yes, Your Honor. I understand now what happened. This took place when I was out sick and monitoring the trial via Blue Jeans, and it was my understanding that some sealed transcripts may not have been delivered. I believe that Real Water may have lodged these in an abundance of caution. I had staff deliver transcripts down to the court.
On January 26th,
That's right.
do you all recall the agreement of all parties? That there was one day after the calendar call, and that otherwise you couldn't, all parties agreed, right? Because you were all in an equal playing field, that everyone had that same one day, and if you didn't do it by that one day, that you couldn't use the depositions?
I understand, Your Honor, and I believe that they were lodged previously. These may be duplicates, and instead of verifying ahead.
Counsel, okay. I have a challenge right now. Attorneys are responsible for knowing what they submit to a court, and not just papering a court over and over and over with different versions, and nobody seems to know. And if you're not, I mean, look at the esteemed counsel you got on this, right? With people agreeing on their pro hoc fee change, being down to the court rules.
I understand, Your Honor.
Did nobody check to see if they were duplicates? They went over after calendar call, you went over the depositions that were lodged, right? Properly and timely lodged. In fact, remember we read exactly from the sheets, which were the 10 boxes, that referred to and confirmed whether those were plaintiffs or anybody else's. Then Mr. Odou stood up and then said that he hadn't done the plaintiffs. And there was a question about Dr. Regime, and Dr. Hutson came up specifically. I remember Dr. Regime because he was going to testify, right? So through all of that. And so is it just a bunch of things you're just going to keep dropping off for the court to ferret through to see?
No, Your Honor.
Everybody already asked you nicely multiple times, including when you dropped off the unfiled copies and then other copies, and not telling us whether or not they were the same things of a whole bunch of different things, untimely of course. I mean, folks, we have a jury outside. We're trying to let the jury, and I really don't want to be going through this again. Right, in fairness to you all, I don't like saying this in open court, but we have to know what is supposedly part of the record, right? Because otherwise, you are going to be contending, guess what, this was brought, this was that, right? On different days, which is why this court clearly gave everyone on the same equal playing field at the time of the calendar call non-compliance to get it fixed with the day. And you all agreed that that was the appropriate remedy and that everyone was going to stand by that. And if you don't think that that's the case, then I'll be glad to get the transcript from the calendar call. But people can't just quote say in abundance of caution, we're just going to dump a whole bunch of things and think that's now part of the record, right? You can't engage in ex-party communications, and some attorneys should, why would anyone from your firms be contacting, think it's okay to contact a JEA anyway without CCing anybody else? And there's no attorney oversight?
It was purely administrative. There was no intent.
It's not purely administrative to engage in ex-party communications. Please read the rules of professional conduct, right? I can pull it out right now, 3.3, 3.4, right? If my recollection off the top of my head. doesn't have specific requirements that the attorneys have to oversee the actions of their staff. Please don't throw your staff under the bus. You're telling me no attorney reviewed something before a communication went to the court? Is that the customary practice at your firm? Hopefully not, but it seems to be the customary practice in this case, folks. And the reason why it's taking time, our jury's standing out in the hallway. I'm not able to resolve your issue, right? Because we don't even have a clarity of whether or not we have a timely deposition. You got two people with Prohocs that keep on saying that they're going to comply with the court's rules, and yet nobody seems to be overseeing that they are complying with the court's rules. You got local counsel who's supposed to be ensuring that, right? The courts, the statement, of course, does not in any way impact any of the court's affirmative rulings on any substantive matters, but you understand we need to continue to give you the benefit of the doubt that this non-intentional conduct to harm the case is really getting paper thin when people are engaged in rule number 1, no ex parte contact with the court, right? Rule number, okay, so counsel, so the deposition that we have is from Real Water, is that correct? And that's the official deposition for Dr. Hutson, is that correct? Counsel for Real Water?
It is, Your Honor. We just got further confirmation from litigation service.
And you can appreciate why the court has to ask, because I keep on getting all this stuff dumped in a whole bunch of different days, and when I ask people whose it is, nobody seems to know what I'm talking about. So, okay. So, with that point cleared up, then the court can consider Dr. Hutson's deposition if it was properly lodged for purposes of evaluating what was and was not stated. At this juncture, the court does not find anything different to change. Well, first off, I don't see the court being asked to change its ruling, because I was clearly stated I was not asked to change the court's ruling from yesterday. So the court's not changing the ruling. The court's going to take into account the 7.27 brief the same way the court would take into account any 7.27 brief. All parties have a full opportunity to provide this court 7.27 briefs, as it does in any case. It's straight out of the EDCR, and so I'm going to take it into account. I'm going to have to, of course, listen to the way the question is phrased, and listen to an answer that is given, and to see if there's any objection before the answer, or a timely objection for the court to address, and I'll continue to do so, as I've done so fairly and equitably throughout the trial. But I unfortunately have to again caution, please comply with the rules. Please ensure, and everybody knows who I'm speaking to, I'm just trying to say it nice and neutrally, but this continued pattern of disregard, okay, in basically so many different areas is very, very concerning, because it's impacting the trial. It's taking time away from our members of the public, and the court's going to need to address it. Not this moment, but I'm going to need to address it. Marshall, can we see if our jury is ready? We understand we have them all here. Okay.
Your Honor, can we see the actual deposition transcript that you awarded lodged? Just to confirm.
You don't want the answer? Hold on. This is what the court understands was lodged. Like I said, my wonderful clerk is.
Your Honor, we may have a problem here. These aren't the ones on this case. This is the Gallagher case. This is not the Hunwardsen case. This is June 9, 2023. This is not the right one.
Okay, hold on a second.
And let Mr. Odou see it, because he'll be able to confirm the dates and all.
Okay. This court needs a point of clarification, please. Was Dr. Hutson specifically deposed in Hunwardsen in addition to Gallagher? This is one of the depositions that was for all purposes based on court-ordered discovery. I'm going to ask everybody's opinion on that page.
Very good question, Your Honor. Indeed, he was deposed in this case. I brought a copy of that deposition so I can bring it to the court so you can see it as well.
Okay. So does everyone concur that Dr. Hutson was disposed specifically for the Hunwardsen case rather than it being a deposition that would have been for multiple purposes and would have been appropriate in the Gallagher case?
Valerie Rojas for ETT. Yes, Your Honor. Dr. Hutson was deposed twice in June and then October, so I do agree, and that's what I was referring to earlier when I said both
Okay,
transcripts.
so Mr. Odou on behalf of Real Water.
That is correct. The deposition transcript and Gallagher matter were delivered by litigation services, not Hunwardsen matter.
Can you understand when the court was confused because we get
Yes, Your Honor.
Actually, the court's not confused. It looked like it was the wrong things, and we didn't think it was the right thing for this case.
That's true. We did not.
Your Honor,
Okay, so what
I've
are we
known
doing?
Mr. Odou for many years. I don't believe he would close something like this
Even
knowingly,
though they were delivered, I don't think, I'm not taking anything negative, folks.
but
We need to move this case forward. We need to deal with the substance of the case. The challenge is, and I appreciate multiple attorneys doing different things and multiple things, and nobody likes the fact that we have to keep going back to all the problems, but they are reality, and they are impacting the case. The court has an obligation to do so in its gatekeeping function, as much as it doesn't. It's not the part I enjoy of the job, okay? Listening to excellent oral arguments, etc., wonderful part of the job. This part, no, part of my job. And you know, it's part of the obligation of a court. So, that being said, it's not the court, you can appreciate he was asking all the questions about the Hunwardsen depositions, right? Because the only ones we had seen were Gallagher. Once again, we need the point of clarification about whether or not, I say we,
Your Honor, we just ask that the rules be enforced, especially given the gratuitous remark made by Ms. Rojas in terms of the rules. And again, this is not a slight on Ms. Rojas or Mr. Odou. He believed he saw what was apparently a certified transcript. It was not.
Mr. Parker, you're going to stop you for a second, because shouldn't we let Mr. Odou speak? Because I think Mr. Odou said he was in charge of the 5 plaintiffs for his firm. I believe he said his co-counsel was in charge of the 2 doctors. And I don't want to speak to you,
Okay, good
Mr.
enough.
Odou, but let me just get a clarification of who presented it, because I'm hearing you say things, and Mr. Odou.
Your Honor, Joel Odou for Real Water. We presented the plaintiffs. We did not see these transcripts before they went to the court because we were in a hearing that day.
We being, who's the we?
I was in a hearing that day. I believe that our co-counsel contacted litigation services to have them provided. I can't speak to those conversations.
So let's go remedy, folks. Is anybody asking for a remedy, or is it as simple as switching out the Hunwardsen depositions for the Gallagher depositions? Or is somebody requesting something different?
We are
Let me just find out what people are requesting.
We are seeking a remedy, Your Honor. They should be foreclosed from using it. They can't use it in this argument. They can't use it going forward. Mr. Odou said himself that we were given a day following the calendar call. It has not been done. We're in second week of trial. It is too late now to remedy it from the defendant's standpoint, Your Honor. So I would suggest that it cannot be used or considered in terms of the argument currently before the court, or going forward, I should say, and it cannot be used in this trial at all. Oh, by the way, Your Honor, I still gave you the Alcina one. I'm going to need that
What
one.
is the that? Just so we're clear.
Oh, that deposition transcript,
Oh,
Dr. Hutson's deposition transcript.
or,
For purposes of arguments, like we've done yesterday and presently today, or in trial.
okay. Bill Water, you've heard the request of plaintiff's counsel. Would you like to respond? And realistically, more than one person is going to be able to respond on this, because different people were handling it. And I think that's the fair thing to do. So, Mr. Kemp, if you want to do final words, I'm going to let you do final words. Fair is fair to everyone, okay?
Your Honor, can I get the Alcina deposition just in case? And I apologize, I
No
just
worries,
believe
it
it
was
there.
right here. That's right there.
Thank you, Your Honor.
Okay, go ahead.
And Your Honor, I just start off
Mr. Love,
by,
on behalf of Real Water.
Mark Love for Real Water, start off by just falling on my sword and apologizing. It was our understanding that we had directed the services to lodge the Hunwardsen transcript.
Did
Apparently,
you personally make the phone call? Who's the person who made the phone call? Do you know?
it wasn't me personally, it was been.
It was my assistant on behalf of my request. We got confirmation of delivery, we even got a picture of it. Because of the cover letter, we didn't see that it said Gallagher. It just miscommunication at some point why it wasn't the Hunwardsen
Do you have
deposition.
an email or something that says that you asked for Hunwardsen? This litigation services issues or digital firms?
I've got an email chain here between myself, my assistant, and the services. And that's where we got the confirmation and time it was delivered and everything.
I'm trying to get an understanding. I request from plaintiff's counsel not to be able to utilize it, right?
All I can say, there was a mistake made, and I'll leave that up to your discretion.
If you use the word the court's asking if you have an email chain, right? Do you have something that says that you specifically asked the services for Hunwardsen and put the right case number versus just gave a doctor's deposition and didn't clarify which case it is? I would appropriately need to take that into account, right, to find out whose error is on behalf of. While you're looking that up, should I circle over to ETT, or do you want to pause for a second? Do either.
Valerie Rojas for ETT, Your Honor, we have no position on this.
Are you claiming you ever timely provided Dr. Hutson?
No, Your Honor, we're not claiming that.
Okay, once again, did you join with Real Water and that you had them do it on your behalf?
We did, Your Honor, but if the result is we can't use Dr. Hudson's deposition, we're fine with that.
The court's asking the question is if you were asserting that there was some communication between you and Real Water and they were taking the weathering more, I would need to know that, right, in fairness? Or if it's just an assumption or whether there was a direct communication?
No, Your Honor, I remember the day and I remember the calendar call and this issue coming up, and we had not lodged those depositions. After that, we did communicate in the hallway with Real Water, but frankly, I remember the plaintiff's depositions were going to be lodged. I don't really remember what else we talked about that day. I didn't even remember that we paid the charitable donation until Mr. Odou just brought it up, so.
I don't know, no one gave us a proof of donation to my knowledge, so just taking it on people's words. Okay, counsel.
Eric Freeman for Real Water. I've reviewed the email and I'll take responsibility. It has the Gallagher name and Gallagher deposition date. So it was just an oversight, a mistake, and I'll leave it to the court's discretion.
You say coming from counsel or coming from lit services?
Oh, no, it was from my office to Lit Services. We requested the Gallagher with the Gallagher date to be submitted, and I didn't catch it, and the wrong one was delivered, so it's a mistake by my office.
I'm deferring what I'm doing about that depot until lunchtime because I'm realistically, I'm going to. How does it impact the depot right now for Dr. Hutson? Because unless you're planning on using it during his inquiry on the stand, then I don't see why the court couldn't wait until the lunch break, so we're not imposing upon the jury any longer. And I take a look at the issue, right? Because you can appreciate the court's been given a variety of different pieces of information from different people that kind of had an evolving nature to it. I want to fully be able to evaluate everything. So, counsel, is there an impact to you if I wait till the lunch break?
Your Honor, we will give the court as much time as the court needs. The only thing we wanted to point out, Your Honor, we gotta just clean up that one, but, because you're not using Dr. Hudson's I'm not using his
deposition.
deposition during my direct examination.
Okay, so it doesn't impact you?
It does not, only for the issue that we raised earlier this morning, which is the 727 brief and how their comments to the court was leading the court in a certain direction based upon what they said their deposition included. That is a problem.
Sure, but in the and the reason why I'm stopping you is because in 727 brief, I did not see a quote from Dr. Hudson's deposition. I only saw a quote from Dr. and I mispronounced Alcina, who was asserted to be one of the defendant's experts, because that's cited on page 4 of the brief. So I didn't see how Hudson's deposition was part of your 7.27 brief. Right?
Yesterday,
Okay.
Your Honor, the defendants made comments about his deposition. And today, the question of using his deposition to defeat our, going forward, how we would question Dr. Hutson was being used as a sword. And so the court, I will tell you, the court asked two questions that we intended to ask the court to inquire about. And you asked them without us asking, other than for us to see the transcript itself. Your Honor, you were misled for the last 35 minutes. And the only way we're aware of it is because the court had the ex parte communication,
Whoa,
received an ex parte.
Yeah, the court did not have
The
any ex
court
parte
didn't have it.
communication. The
Received.
court, I think, made it abundantly clear, did not review any said ex parte communication, was aware there was something.
Exactly.
Aware it involved things that are sitting outside, and so the court just left those things sitting outside and really was waiting for someone to bring it to the court's attention so it could be addressed fully and fairly in a nice, open court setting.
Absolutely, Your Honor. And by me saying what I said, Your Honor, I was not trying to suggest or imply that this court engaged in ex parte communications. I'm saying that ETT's counsel sent ex parte communications to the court, and it wasn't for the court advising everyone here, the plaintiffs would have never known. We would have also never known, and the court would not have known, because we were taking counsel at their word, that we had Gallagher deposition transcripts as opposed to Hunwardsen deposition transcripts. If it wasn't for the court asking, we would have never gotten that. In fact, one of Real Water's counsel was under the belief that his co-counsel actually deposited and lodged correctly the right Hunwardsen deposition transcripts, which was not done. Your Honor, I don't know how many times we have to hear of violations of our professional rules of conduct before the court takes, I would suggest, serious steps, and you've admonished everyone. But this, an ex parte communication, and unknowingly deceptive comments regarding those transcripts lodged, that can't be condoned, and it should not prejudice the plaintiff's position on this issue or any other issue going forward. But we can't, long story short, we can wait until after lunch to get the court's position on it.
You're always free to tell a jury to do something different, but I will listen to it. Because
That's
you all have stated over and over, you want the jury to be able to, that you have a witness who needs to fly back to certain
Yes, we want to bring
locations.
them
So
on.
remember, the court's trying to take all of those into account to ensure a full, appropriate trial for everyone, but when conduct comes to the court's attention that people are asking the court to address a particular matter, the court's going to address the issue. So at this juncture, here's where the court is. I have what I said before, I have a 7.27 brief. The court's ruling yesterday was based on everyone having a full opportunity to engage in oral argument. You could point to what people wanted to point to. You went pointing to the expert reports and the rebuttal reports were handed to the court. The court inquired about particular paragraphs and particular side effects, etc. Everyone had a full opportunity. Everyone had a full opportunity to be prepared because we waited until later on in the day to do it outside the presence of the jury. You all had the opportunity to make whatever record you wanted to based on the information provided to the court yesterday. The court made its ruling. The court does not find that there would be any basis to change its ruling from yesterday based on, remember, it was a particular question and an objection that it was outside the scope of the witness's designation by ETT and then joined by Real Water. That was the very narrow issue before the court. That was the very narrow issue which the court ruled on. The issues that have come up today is an interesting hydra, but it's going to be dealt with tentacle by tentacle, piece by piece, so that everybody is getting their full. Yeah, I didn't. I
didn't know if you caught that. I had to go ahead.
I got that, Jerry.
Okay, so, yes, I don't want to use the term under negotiations, etc. So that being said, the court is going to address this, but the court has to take into account that the parties have asked this court to move forward, that you stated you have a witness that needs to get a flight, you need to ensure everyone has an opportunity to do the examinations that they're allowed to do. The impact of the deposition I do see potentially may come up. Who knows with regards to cross-examination, which is why this court was saying it was going to address it at lunch versus the end of the day. so that I can evaluate things and at the same time give everyone an opportunity to evaluate things and so everyone is fully prepared. But if you are asking me to address it now, then I'm gonna have to look into a couple of different things and you're gonna have your jury waiting. So I'm gonna ask you each what you want the court to do. Move forward or address it now.
Move forward, Your Honor.
Real water,
I agree, Your Honor, ready to move forward.
ETT.
Valerie Rojas for ETT, we'd like to move forward, Your Honor.
Okay. Then based on the joint request of all the council, would you like to bring our jury in?
Thank you, Your Honor.
Remember, question by question, folks, that's what's rules. Thank you so much. Unless otherwise governed by a motion of the or other court orders. Thank you.
No, go ahead and set up.
Oh, of course. Please, do you need the podium turn?
I'm gonna turn it a little bit,
Yeah.
that's okay with the board.
Turn it. And are you all doing it on doc cam or we present so that you can use the mouse or not?
We're on doc cam, Your Honor, so no mouse control for the witness.
Okay, no worries. Got it taken care of, okay, because that was the, Go ahead, Marsh.
Okay.
Yes, thanks so much.
Come on in, folks. Everyone, please be seated.
Thank you very much. Council, would you like Marshall to get the same with the
That would be great, Your Honor.
Appreciate it. Thank you, Marshall. Appreciate it. Welcome back, ladies and gentlemen. Well, best laid efforts, but effectively, you saw council was in here working. We're trying to get things done as expeditiously as possible. Sorry you had a little bit more weight. Best estimation of time did not work out as perfectly. So my apologies on behalf of the court. Once again, I go to my last name, Ish. Okay? I got my Ish, and I use it as much as I need to. Thank you so much.
Good morning. Good morning.
Good morning.
How are you guys?
They're good.
I'm gonna give you up front, by the time I got to the optometrist, it was closed at 6. So I still got the same glasses. You can tell these are different. They got the little round thing in there as opposed to the ones that kind of sit on your nose pad. So which means I'll be getting closer to that. Just to let you know. Good morning, Dr. Hutson. How are
Good morning,
you?
Mr. Parker.
How's everything?
Good.
Good. All right, proceed.
Of course you.
Or-
Let me just remind the witness, pursuant to our protocol, witness understands you're still under oath, correct, even though we have some new day.
Yes, yes, ma'am.
Appreciate it. Thank you, counsel. Feel free to proceed with the next question.
All right. Your Honor, yesterday we showed Exhibit 394001. And the court was kind enough to discuss with the parties how that exhibit may be a video as opposed to a still photo. And so we want to make sure the record's complete. Mr. Godfrey, how long is that video?
9 seconds.
Can you play that video so that the jury knows what this exhibit is? It's not just a still photo. Photo is actually a 9-second video. Your Honor, may I show the exhibit to anyone? I believe there's no objection to it.
Here, there was a stipulated, sorry. 1 second.
So can you play it without sound?
Any objection by real water?
Yeah, I can.
Not if it's silent.
Yeah, without sound.
Any objection by ETT?
No, Your Honor. Not
By
without
hearing the
sound.
parties? Normally we would show video without sound unless there's some specific reason that you need to have sound, so you may show it without sound, but just, thank you.
Is that 9 seconds?
Nope, it's not like that.
It's the quickest 9 seconds I've ever seen. Unless 4 of them are black seconds, I mean, I'm not. So, Dr. Hutson, when you're doing these transportations from one facility, one medical center, that perhaps does not have the technology to do a transplant, to another one, is this normally the scene?
Yes, sir.
And you're, not only is he strapped down to a gurney, but there seems to be things attached to him.
That is correct. He has to have monitoring equipment. Typically, these people have IVs running, they have oxygen.
and at least 2 medics are with the patient at all times.
And that's just, is that normally done flight to life? Is it done by vehicle? How's that typically
Now,
done?
typically, you know, if there's some distance involved, then it's by flight. And so this would be by flight, because you really don't have time for ground transportation,
Understood.
unless you're in the same city.
Yes, sir. Now, Doctor, I want to go over, because we've gone over the steps of Mr. Hunwardsen's transplant. But I want to go over where we left off yesterday and discuss his future, okay? And then after that, we'll discuss your overall opinions, and then we'll conclude, and I'll transfer you or allow the other attorneys to question, okay?
Yes, sir.
Now, in terms of Mr. Hunwardsen's future, it's my understanding that he will be required to take anti-rejection drugs, which we talked about yesterday. Is that
That's
correct? One other thing, and I don't know if the jury caught this yesterday, we're going through the medical records. From your evaluation of the medical records, and of course your discussions with all the plaintiffs, is it clear that Mr. Hunwardsen actually consumed real water longer than the others?
Yes, sir, it is.
Based upon your investigation, it appears he was consuming it from 2016 to sometime around 2019.
That is correct.
If you could show slide 71. Now, these are things that you've opined on, correct?
Yes, sir.
Is it just simply based upon your experience, your education, that the anti-rejection drugs is immunosuppressants are simply to allow the new liver, in this case, to survive within Mr. Hunwardsen's body because it's foreign to his body?
That is correct. And a recipient's body immediately knows that that foreign organ is in there. So in the OR, we have to give we start the immunosuppression in the operating room at the same time that new liver is put in. That's how quickly the immune system starts beating on that new organ.
So the new liver is attacked as soon as it's implanted into Mr. Hunwardsen?
Yes, sir.
And let's say that this new liver doesn't work. Does Mr. Hunwardsen get a chance at another liver?
He would. If this was occasionally we see patients that develop severe acute rejection or acute liver failure in the organ itself, in the graft. It's not very often. It's pretty rare. But if it happens, these people then go to the top of the list again. Remember yesterday we talked about status 1? Now status 1 is the very top in the whole region, so they go above everybody else. That would happen on somebody like Mr. Hunwardsen as well. He's a young guy. He's otherwise healthy. If that liver were to fail right away, he would get a shot at another organ.
All right. And Dr. Hutson, because of all of the functions of the liver, if the anti-rejection drugs are not effective, that person dies.
That is correct.
So there's no in-between other than anti-rejection or death.
Yes, sir.
Go to slide 72, please. I want to discuss these actual drugs for a second, okay? So we understand that the anti-rejection drugs are to protect the donor's liver. But tell me about these drugs, because I know there are side effects of these drugs. Is that correct?
Yes, sir.
So let's start with the tacrolimus.
Tacrolimus is our main anti-rejection drug. It's the one that we rely on the most. It's called an IL-2 inhibitor, interleukin-2 inhibitor. So each of these drugs attacks is maybe not the best thing to use, but addresses the immune system of the recipient in a different way. And so that's why we use different drugs, particularly starting out. Prednisone is absolutely essential because it has a really over-covering effect of the immune system. Tacrolimus and mycophenolate are more targeted towards certain parts of the immune system. But you need all three of those to start out with because that's when you have your most chance of rejection is early on when that organ is first placed in the body.
And he'll be taking these drugs twice a day for the rest of his life?
He'll be taking 2 of them. We try to get rid of the prednisone within 3 months. While prednisone is a great drug and it works wonderfully on preventing rejection early on, prednisone also, if any of you have ever taken prednisone before, it has a lot of side effects. So we try to get people off prednisone within 3 months and then maintain them on the other 2 drugs.
What kind of side effects come along with prednisone?
Well, there's high blood pressure, there's diabetes, there's cataracts, there's bone softening, there's skin changes. All those things are part of prednisone.
All right. And is that just common knowledge in the medical industry?
Yes, sir.
And when I say industry, I'm trying to find the right word. I say industry because that would include the pharmaceutical companies, correct?
Yes, sir.
Okay, so the doctors know it and the pharmaceutical companies.
Yes, sir.
Do they typically have warnings or information like that about the use of prednisone?
They do. It's in all the package inserts and it's common knowledge. You know, it's in every textbook you pick up. It doesn't have to be a GI or liver textbook. It's every textbook has the side effects of prednisone and the dangers of long-term use of it.
Would that be the same for tacrolimus?
Yes, sir.
And the other drug, mycophenolate,
Yes, sir.
would that also be the same?
Yes, sir.
So all of those drugs have known side effects that are well known, I guess, by pharmaceutical companies, by doctors, and in the literature.
Yes, sir.
And would this literature include peer-reviewed literature?
It does.
Would it also include treatises or articles within well-known and respected medical societies?
Yes, sir.
Like the gastroenterology or hepatologist type articles, of American Medical Society.
Bless you.
Bless you. Let's take a look at slide 73, please. And Your Honor, slide 73 is actually exhibit 628. It's been stipulated.
Appreciate it. Thank you.
You're welcome. If you look here, you can see that the immune suppressant medication, tacrolimus, as well as methylprednisone, is being provided to Mr. Hunwardsen. Is that correct?
That's correct.
And is that something that you typically do right after the operation, or as you said, during the operation?
This is standard medication following a liver transplant with the, as I said, the methylprednisolone is given in the OR as soon as the new liver is placed.
Yes, sir. I want to drill down on Mr. Hunwardsen a little bit more, but I want to make sure that in terms of all of the plaintiffs here, will they also have to be monitored and perhaps have some form of liver function test twice a year the rest of their lives?
Yes, sir.
Well, let me ask it this way. How many years do you foresee having everyone, with the exception of Ms. Brody, having liver function tests? And I want you to exclude for right now Ms. Brody and Mr. Hunwardsen, okay? Because they're a little different. And in terms of Ms. Sosa, Ms. Hartshorn, and Ms. Schaefer, how long do you foresee them having to get liver function tests?
I would say they should have that for 20 years
All right.
to make sure that there's no long-term effects and insidious scarring that occurs.
Bless you.
Good. All right. And Ms. Brody is just a couple of days older than the rest. How many years do you think she'll need to get the liver function test?
Probably 5 years.
All right. Thanks. In terms of Mr. Hunwardsen, will he have to get monitoring by some form of hepatologist or transplant hepatologist the rest of his life?
Lifetime, he will need to be monitored, yes, sir.
And will that also include drug calibration?
It will. We always have to have drug levels of the tacrolimus. You guys see that on the top of the list there. So we measure levels because tacrolimus side effects largely will be sort of controlled by having the proper level. If that level goes too high, people get a lot of side effects. But if you keep it in a reasonable thing, and we know what the reasonable numbers are as time goes on, because you need a lower and lower level the longer that liver is in there. But it still has to be monitored. We usually do it on a monthly, after people are out of the hospital and doing well. So 6 months, we're down to once a month, usually on measuring the levels of tacrolimus.
And so, slide 76, please. Oh, you're good.
The number one more time, Mr. Parker.
Let me take my glasses off. Yep, 76. So we're going to go through the side effects dealing with some of these drugs, okay?
Yes, sir.
Talk about tacrolimus. Does tacrolimus place Mr. Hunwardsen at risk of getting skin cancer?
Yes, sir.
Let's go to Exhibit 391. I believe 391, there's no objection to that document. Don't put it up until we have confirmation. Mr. Doctor.
That's proposed.
Yes, it is proposed, Your Honor.
Any objection, counsel?
No objection from Railroad.
391,
Yes,
no objection from me.
Issue? Okay, so is it stipulated admitted?
it is, Your Honor.
Okay. Next one.
So this is a medical record from the, related to Mr. Hunwardsen. And it says here, taking immune suppression medications put you at a higher risk for skin cancer. It's recommended that you see a dermatologist yearly for skin checks. Why is this?
Because you're altering the immune system with tacrolimus. So you're more prone to skin cancer based on that.
Is that something that's in the literature as well?
Yes, sir.
Now, I ask you that because I'm not asking you as a pharmacist to tell me how the drug is made. I'm asking more in terms of a fact. Does everyone accept that tacrolimus can cause skin cancer?
Yes, sir.
There's no doubt in your mind about that?
No doubt.
There's no doctor in your opinion that would say otherwise?
There's no transplant hepatologist out there I know that would say that there's not that risk.
Next slide, please. Does tacrolimus also subject Mr. Hunwardsen to high blood pressure, cardiac events?
Yes, sir.
And as well as prednisone, but why is that? Is it the same reason?
It's a little bit different than the immune system. With tacrolimus, it actually causes the blood vessels to constrict in the body. So when those blood vessels, systemic blood vessels constrict, then they become a little bit more stiff, a little bit more rigid, and therefore blood pressure goes up.
And does tacrolimus and or prednisone also affect the bone density of the person in a patient taking?
Yes, it does. Primarily the prednisone.
Go to 79. So is that something that Mr. Hunwardsen will suffer? A bone density deterioration because of his lifetime commitment to tacrolimus?
In all likelihood, it will. Maybe not since he's so young right now, not now, but later on in life, he definitely has that risk. So he'll need to get bone density monitoring on a regular basis. It's recommended about every 3 years that they get bone density monitoring, or more often if the initial scan is abnormal.
Yes, sir. Now, you know that Mr. Hunwardsen worked as a steel worker.
Yes, sir.
With these concerns, the bone density loss, the skin cancer, being outside in Las Vegas, would that prevent him from being able to continue working at that job for the next 20 years, 30 years?
It possibly could later on. It won't be an early or immediate effect, but later on that could affect his ability to do heavy manual work.
Would it also affect his ability to be outside in the summer in Vegas?
Yes, sir.
Is that a reason you believe that later on, depending on how long he lives, that he may not be able to do that job anymore?
That's correct.
Now, does tacrolimus also affect your renal or kidneys? Renal system or your kidneys.
Yes, sir. It has a direct toxic effect on the kidneys.
And how does that work again?
Well, the tacrolimus itself has a negative effect on the kidney tubules themselves. So these are the little tiny tubes inside the kidney. So it causes those tubules to constrict. So you have, and it also causes the blood flow going into the liver, what we call the efferents going into the liver. I'm sorry, into the kidney, pardon me. It causes the efferent vessels going into the kidney to narrow down. So you have a narrowing and a decrease slightly, it's not a lot, but a slightly decreased blood flow, but it's enough to give that potential for kidney problems. And in the bulk of the patients that I take care of, they all have at least some type of kidney disease. There's 4 stages, there's 5, 0, 1, 2, 3, 4. 4 is when you can get to the level of needing a kidney transplant. Now, most people don't end up needing a kidney transplant, but some do. I've transplanted a bunch of my patients over the years, but somewhere in that realm of stage 1, 2, or 3 kidney disease.
Now, mycophenolate, what side effects come along with that, with the use of that drug? And I want to make sure we're clear. I want you to have to give me opinions. So if it's an opinion, you tell me. But if it's a fact, something that's in the literature, something that's in the treatises, something that's in the warnings of the actual medication itself, that's the question, that's the answer I'm looking for.
Okay.
So tell me what factually are the side effects of mycophenolate?
Well, mycophenolate is what we call an anti-metabolite. So its function on immunosuppression is way different than tacrolimus and prednisone. It's a bit more of a mild anti-rejection drug. It's not nearly as harsh as tacrolimus. So we typically do not see kidney disease with the mycophenolate. In fact, we use mycophenolate along with tacrolimus so we can run those tacrolimus levels lower so that there's less kidney toxicity. So it kind of helps us protect the kidney a little bit. But it's still an immunosuppressant. So you have all the same side effects of immunosuppressants from that you do the others. So suppressing the immune system. And then in female patients, you cannot be on mycophenolate and be trying to have children because it can cause birth defects. And the male also has to be off mycophenolate.
Objection, Your Honor. Move to strike 16.1. Can we approach?
Join beyond the scope.
Feel free to approach counsel. Objections that were pending. Witness can either continue to answer or.
Thank you so much. You can continue your answer. Dr. Hutson. I'll tell you where you started, and then when you left off, and you continue from there. You were talking about the side effects of mycophenolate. You started talking about female inability or shouldn't take it while they're try to have children while on this drug. And then you were transitioning to the males.
Yes, sir.
But you can continue from there.
So-
I think that's where you left off.
Okay, that is correct.
All right.
So while the female is the most at risk of having birth defects when they take mycophenolate, so you have to make sure your females are off mycophenolate for at least 3 months.
Objection, Your Honor, beyond the scope, this is hearsay as well.
Overruled on both bases with the way the question was phrased, the witness's answers thus far. Witness may continue.
Go ahead.
So it's recommended in the medical literature that the female recipient is off mycophenolate for at least 3 months before they try to conceive. And likewise, the literature has shown that if the male that has had the transplant and is taking mycophenolate, that can lead to birth defects as well. So the male also has to be off mycophenolate for at least 3 months before they try to conceive.
And if a male or female pulls away or stops taking that mycophenolate for that time, are they jeopardizing their life?
No, sir.
Objection beyond the scope calls for hearsay.
Hold on just a second.
I'm not talking about Mr. Hunwardsen or anyone else.
I know the not from the jury, folks, feel free to approach, and the
Understood.
jury will disagree with the colloquy between counsel. Thank you so very much. Appreciate my team from Norm earlier, so we need to make sure that they get their morning break. So, ladies and gentlemen, during this recess for the next 15 minutes, it's 11:30. You're admonished not to talk converse among yourselves with anyone else on the subject matter for this trial. You may make it 11:35. You may not. Okay, let me go and start back early. During this recess, you are admonished not to talk and converse among yourselves with anyone else on any subject connected with this trial. You may not read, watch, or listen to any report of or commentary on the trial or any personal entity connected with the trial by any medium of information, including without limitation, social media, text, tweets, newspapers, television, internet, radio, and if they are not stated specifically, is also included. Do not visit the scene of any events mentioned during the trial. Do not undertake any research, experimentation, or investigation. Do not do any posting or communications on any social networking sites or anywhere else. Do not do any independent research, including but not limited to internet searches. Do not form or express any opinion on any subject connected with the case. So sworn and finally submitted to the time of jury deliberations. With that, have a good week. Enjoy stretching your legs. Thank you so much. Okay, so I was just checking with my wonderful team. I need to make sure. So we'll see you back 15 minutes. And then, yeah, you can leave. What you did, I do need everyone to leave the courtroom so my team can get their break. But you're more than welcome to do what you need to leave. Like I said, as long as it's not alive or dead or trash. Thank you so much. Being a factual statement that addresses side effects based on the court's ruling on Friday and with the information presented to the court at that time, including the expert report and the rebuttal report. The court wouldn't see that there was, for that specific question, any opinion provided in either of those reports. That's a court's inclination.
I will draw, John.
Okay, so then you want me to say it's withdrawn and, okay?
And no action for the court to take.
Okay, let me hear from everybody else. Sorry, you're gonna say it on the record from the jury?
That's on me. I'm more than
I'm not
happy to say
requiring, it's
withdraw.
just a question, I'm asking you yours, and then I'm gonna circle around to everybody else to get their viewpoints, okay? So that's what, Councilor Plaintiff, does that address any concerns by real water? You spoke first?
Yes, Your Honor, as far as this particular question goes, we still obviously have concerns about future questions, and obviously the court can't address future questions. But,
Anybody would like to turn my beautiful crystal
Yeah.
ball into a working
Right.
crystal ball,
But-
please let me know, it would make my job easier, but it's not,
we're
I
just-
ask you question by question.
We're just concerned about
Okay.
opinions masquerading as facts,
And all the able counsel who feels that that occurs, feels that they have a right to do an objection, the court will address any objections when they come on. Appreciate
fair
it.
enough, yeah.
Counsel for ET&T.
Valerie Rojas for ETT. Since the question is withdrawn, obviously our objections are no longer applicable. I share the concerns of real water that this is going to keep coming up question by question, and we're going to have to continue to address it outside the scope, but be that as it may, I understand the court would like to take it on a question by question basis, and so that's what.
Not the court would like it to. Can you provide me any case law, any rule that says that the court can make a speculative, unright decision without having the facts and information before it?
No, Your Honor, but I think we all
The
understand
court
what the
wouldn't,
issue.
couldn't, and doesn't.
Okay.
And there's a whole body of case law in the Dow that says, I can't, anyway, right, it says it has to do right. Questions, waive, okay.
Understood, Your Honor.
If you all wanted to do a motion lemonade, people could have time to do what they needed to do. So everyone had a full opportunity to address it if you wanted a more global context. You chose not to, which means the court needs to address this question by question. At this juncture, okay, so counsel, you ready to bring the jury back in?
I am, Your Honor. Thank you so much.
Yes, Your Honor.
Thank you. Sorry, UTT, I didn't mean to skip you. I saw your head go up and down, so do you want to answer the question? Are you okay?
Yes,
Marshal's
we're-
waiting.
We're
Okay.
good with having jury back.
Appreciate it. Thanks, Marshall. I want to make sure I had everything all good. Thank you. Does anyone mind if counsel tells the witness to come back to the stand as well, so we save a minute? Is everyone okay with that?
That's fine.
That's fine.
Thank you.
I heard multiple people, so whoever's answering it, I'll be. Thank you. Yes, Marshall? Marshal, we are ready. Thank you so very much.
Thank you for standing, everybody. Come on in, folks.
Your Honor, all members of the jury are present. Everyone, please be seated.
Okay, thanks much. Welcome back, ladies and gentlemen. Okay, counsel.
Yes. May I proceed, Your Honor?
Oh,
Dr. Hutson, when we left off, we were talking about Michael Fennelly, and I asked a question. I'm going to rephrase that question, okay? I actually want to withdraw that question and ask you a different question, okay?
and since it's withdrawn, the court need not rule. Thank you so much, Scott, please.
Have you ever seen the actual warnings on the Michael Fennelly bottle?
Yes, sir, I have.
Can you show me slide 82, please? Have you seen this warning?
I have.
And when you prescribe this type of medication, it comes with this warning?
It does.
And is this based upon the facts as you know it, based on the industry, the pharmaceutical itself, the literature, is this the warning that every patient gets when they actually are prescribed that medication?
It is a well-known fact.
And it says here, males who have female partners who are able to become pregnant should also use effective birth.
Could you just move the mic a little?
Oh, I'm sorry.
Kind of in between there.
Yeah, we're
Thank
fine
you.
to give you a pocket microphone if you'd like. If not, we need your arms reach if you don't mind, please.
Yes, Your Honor. Should use effective birth control before and during treatment with mycophenolate capsules. Talk to your healthcare provider before starting treatment with mycophenolate capsules about birth control methods that may be right for you.
That is correct.
All right. Now, I want to transition from now the side effect of mycophenolate and talk about the lifespan, the prediction of lifespan for Mr. Hunwardsen given this liver transplant, okay?
Yes, sir.
It's my understanding, Dr. Hutson, that you believe that the general lifespan for someone having undergone a liver transplant is between 12 to 15 years.
That is what's stated in the literature and is a good approximation for the bulk of liver transplant patients. Right?
All right. Have you read Dr. Alcina's deposition transcript?
I have.
Based upon Dr. Alcina's deposition transcript, is he predicting somewhere around 19 years?
Yes,
20
it
years?
is.
You're hopeful that Mr. Hunwardsen may be able to last longer, maybe even 29 or 30 years?
Yes, sir. When you talk about the median survival that you mentioned at the first, the 12 to 15 years, that takes all comers. Okay, so that we transplant people from babies to, the cutoff was roughly about 65. You can go a little bit above that if you have a really good 66 or 68 or 70-year-old. So that's all comers. Now, obviously, younger people usually have a longer lifespan than older people. So when you do that 12 to 15 years, it takes everybody into account. So the reason I think that Mr. Hunwardsen will probably go longer than that is because he was 29 years old when he got his transplant.
All right. So we can show slide 83, please. All right. So based upon this chart, we start off with his date of birth, and then moving from left to right, we look at the date of the transplant, September 23rd, 2019. And then Dr. Alcina is real waters expert. He's suggesting maybe another 20 years of being able to live after the transplant from Mr. Hunwardsen. And you're hopeful that maybe sometime between that and 30 years. Is that correct?
Yes, sir.
All right. And if you're correct, he would have lost how many years?
That would be, let's see, with a 78 year, 77 to 78 year, he would have lost, what's that, 15 years?
And if your Dr. Alcina is correct, if real waters expert is correct, he would have lost more like 27 years.
Correct.
Right. Now I want to get to some general points as we wrap up with Dr. Hutson. Based upon your review of all the tests performed, I think there were 10 tests total of the concentrate and the water bottles.
Correct.
all tests showed hydrazine.
That is correct.
Dr. Hutson, could you just move the mic a little closer to you?
Oh, sure.
We're doing that, being comfy in our nice comfy witness
Yeah,
chairs.
let me
So
move on.
people lean back, thank you. A little closer to the microphone, appreciate it, thank you so much.
And based upon your experience and knowledge of toxins, hepatic toxins, hydrazine causes acute liver failure.
Yes,
Okay. Based upon your examination of all the medical records and all of the reports, you've also included the Loma Linda report, for example, the MMWR report, CDC. All of the plaintiffs got acute liver failure because of their consumption of real water.
that is correct.
We know that Mr. Hunwardsen had a liver transplant. We also know that both Mr. Hunwardsen and Ms. Schaefer both had biopsies, correct?
Yes, sir.
Based upon your experience and your education, is it your opinion that all of the plaintiffs, with the exception of Mr. Hunwardsen, of course, with the liver transplant, more probable than not, will have liver scarring as a result of consuming hydrazine?
Yes, sir.
And as a result, all of them will need future monitoring for 2 years, for at least 20 years, for 3 of the 5 years for Ms. Brody, and then continuous monitoring by a transplant hepatologist for Mr. Hunwardsen.
That is correct.
Okay. And is it also fair to say that because Mr. Hunwardsen's liver transplant unfortunately makes him susceptible to all of the side effects we discussed earlier, that in his later life, he's going to need hospice care and home care?
Yes, sir, that's my opinion.
And is it your opinion that he will need help, either through hospice or home care, just to manage his last several years?
Yes, sir.
And prior to that, he won't be able to do the same job because he won't have the physical ability to do so?
That is correct.
And do you give all of these opinions to a reasonable degree of medical probability?
Yes, sir, I do.
So let me, in terms of Mr. Hunwardsen, I just want to go through it one more time to make sure I didn't miss anything. Number one, he's susceptible now to hypertension.
Yes, sir.
To a reasonable degree, more probable than not, to a reasonable degree of medical probability. And I just go through the list and you just tell me the hypertension,
Yes, sir.
diabetes,
Yes, sir.
dyslipidemia.
Yes, sir.
Can you tell us what that is again?
That's an increase in cholesterol and triglycerides in the body.
Impairment of his renal function,
Yes, sir.
cardiovascular morbidity and mortality.
Yes, sir.
What's nova extrahepatic malignancy?
De novo extrahepatic malignancy means that you get a malignancy that's not related to the liver itself. Like somebody may get a ovarian cancer, or they may get a breast cancer. So those are what extrahepatic are.
And that can be caused simply because you've had a liver transplant.
Yes, because of the effects of the immunosuppressives over time.
Got it. May subject them to colon cancer.
Yes, sir.
All of these as a result of consuming real water.
Yes, sir.
And then, of course, having to take the immunosuppressants related to keeping himself alive.
That's correct.
And you said he will have to take these medications for the rest of his life.
That's
Question
correct.
asked and answered.
Thank you. Thank you, Your Honor. And I just wanted to make sure, in terms of the medications, it is the tacrolimus as well as the methylphenidate.
Yes, sir.
And without those, you risk none.
Yes, he would reject his liver.
That's all I have. Thank you so much, Dr. Hutson. I appreciate your time.
Okay. Cross-examination by real water. Go ahead.
Yes, thank you, Your Honor. Dr. Hutson, good morning.
Good morning.
My goal is to get us out of here by noon, or close to it as I can, so I'll try to be as brief with you as I can.
Thank you, sir.
I understand you have a flight to catch to get back to West Virginia?
I do.
Okay. You talked a little bit about this Loma Linda article, and that was an article that in essence was case reports of 4 individuals.
That is correct.
And that's a relatively small sample size, isn't it?
Yes, sir.
Okay. And again, looking at the 4 individuals, if we were to take the 4 individuals here, excluding Myles Hunwardsen, and looking at the other 4 plaintiffs, how many of those had biopsies?
1.
Okay. And that was Ms. Schaefer?
That is correct.
Okay. And that biopsy came clear, there was no scarring found?
No scarring found in her biopsy, correct.
So in that 4 individual sample size, 100% of the biopsies found no evidence of liver scarring?
Yes, sir.
Okay. And again, looking at this Loma Linda article, the sample, the 4 individuals that it was taken from was individuals that were already hospitalized with acute liver failure, right?
That is correct.
Okay, they weren't doing biopsies of individuals that drank real water that didn't show symptoms?
No, sir.
Okay. Do you know how many people over the last, 10 years or so have consumed real water?
And no, sir, I don't know how many people consume real water.
Okay. Do you have any information whatsoever as to what percentage of real water consumers actually had symptoms?
No,
I want
sir.
to be honest though.
Overruled.
Do you have any opinion as to whether or not there was hydrazine in every bottle of real water going back the last 10 years?
Again, be honest though.
Counsel, can you all approach medical experts?